Whether you're a seasoned entrepreneur or just starting your business journey, understanding resolutions is crucial for making important decisions within your company. So, in today's video, we're going to dive into what resolutions are so that you know where you stand when you need to make an important decision. Hello there, my name is Ian from Your Company Formations, where we make forming your company as easy as shooting fish in a barrel. Today, we're diving into the world of limited companies and discussing an important topic that often confuses business owners and shareholders. So, what is a limited company resolution? Well, to put it simply, a resolution is a formal decision or agreement made by shareholders or directors of a limited company. It's like a company's version of a contract, ensuring that everyone is on the same page when it comes to making critical decisions. There are two main types of resolutions: ordinary and special. Ordinary resolutions are decisions that require a simple majority vote. Essentially, it's used for decisions that don't have a significant impact on the company as those requiring special resolutions. These are routine day-to-day decisions that can be made by simple majority vote of the shareholders or directors. Here are some examples of situations that typically require an ordinary resolution: approval of annual financial statements, appointment of auditors, declaration of dividends, appointment of additional directors. If the company's articles of association allow, appointing additional directors beyond the initial board may be accomplished with an ordinary resolution. Ratification of directors' actions. Ratifying a director's action or decision, such as signing contracts on behalf of the company, often requires an ordinary resolution. Borrowing money. Authorising the company to borrow money subject to any borrowing limits set out in the articles usually requires an ordinary resolution as well. Issuance of debentures. Decisions to issue debentures or bonds often require an ordinary resolution, depending on the company's articles. Changes to the company's registered agent. Changing the company's registered agent or registered office address can often be done with an ordinary resolution as well. And allotment of new shares. The allotment of new shares within the authorised share capital, subject to any limits in the articles, once again, is typically an ordinary resolution. Now, special resolutions, on the other hand, are more critical and need a 75% majority vote. Special resolutions are typically required for significant decisions and changes within a limited company that may significantly affect the company's structure or operation. While the specific requirements may vary by jurisdiction and the company's articles of association, here are some of the common examples of situations that often require a special resolution. Altering the company's constitution. Any changes to the company's articles of association, such as amendments to the company's name, its registered office, or objects for which the company was formed, typically require a special resolution. Changing the share capital. This includes decisions related to the creation of new classes of shares, the reduction of share capital, or the consolidation of subdivision of shares. Alteration of share rights. Changing the rights attached to a particular class of shares, such as voting rights or dividend rights. Issuing additional shares. Authorising the issuance of new shares or the issuance of shares for a specific purpose, such as granting stock options to employees. Winding up the company. Decisions related to winding up or liquidating the company, whether voluntary or due to insolvency. Changing the company's type. If a company wants to change its legal structure, for example, from a private limited company to a public limited company, this change usually requires a special resolution. Appointment and removal of directors. Special resolutions may be necessary for appointing or removing directors, especially if the articles of association specify this requirement. Changing of the registered office. Selling the company's assets. Decisions to sell, lease, or dispose of any of the company's substantial assets or undertake major business transactions may require a special resolution. Approval of share buybacks. If the company intends to buy back its own shares, a special resolution is often necessary to authorise this action. Now remember, that while these examples are commonly associated with particular resolutions, the specific requirements and circumstances under which an ordinary resolution versus a special resolution is needed can vary based on the company's articles of association, bylaws, and legal requirements of the jurisdiction in which the company is registered. It's essential to review and understand the specific provisions of your company's governing documents and applicable laws to ensure your compliance. You can find more information by looking at the Companies Act of 2006. So now that we have an idea of why a resolution is used, let's find out how the resolution process works. Typically, a resolution is proposed by a shareholder or director and then discussed during a board meeting or general meeting. Shareholders then vote on the resolution. The type of resolution, ordinary or special, determines the majority required for approval. It's essential to draft resolutions carefully. They should be clear, concise, and specific about the decision being made. Once a resolution is approved, it must be recorded and filed with the company's official documents. This ensures a legally binding record of the decision. Limited company resolutions play a crucial role in maintaining corporate governance and ensuring that major decisions are made following legal and procedural requirements. They protect shareholders' interests and provide a clear framework for decision making. To ensure transparency and compliance, it's imperative to document company decisions by creating minutes of all general meetings and resolutions. These records, including the minutes and company resolutions, should be maintained at the registered office or SAL address, the single alternative inspection location. This is for a minimum of 10 years and it should be accessible for scrutiny. Statutory company records and registers must be regularly updated as necessary to reflect any changes or decisions made. In the event of alterations or updates to your limited company's operations, you typically need to inform Companies House. Special resolutions need to be physically delivered to Companies House via post within 15 days of their approval. Electronic submission of these documents is not an option, or at least at the time of filming this video. Ordinary resolutions in most cases do not require submission to Companies House. Instead, they should be retained as part of your company's standard records. Now, if you're unsure about drafting or implementing resolutions for your company, it's always wise to consult with a legal or financial professional who specialises in company law. Or give us a call here at Your Company Formations, where we can provide valuable guidance and ensure that your resolutions are in compliance with the law, and help you with any other queries you may have. As always, don't forget to let us know in the comments any burning questions, and myself or one of our team will get back to you as quick as a whippet. And you can always follow us on our social media pages, which will be in the description below. See you on the next video.